Howdy. Hello there. Not legal advice. With a hopefully a fairly short little video. Like, subscribe. Please comment. Show your animals, especially your doggies. Share with whoever else you want. Ask questions. Make comments. And thanks for your listening and your participation. So I wanted to talk a little bit about MMTLP, a little bit about Citadel, and a little bit about Goldman Sachs. But of course, before I get started, just to keep things kosher and direct, um, in my opinion, Napoleon may not have designed his own coat, but he certainly had a hand in it. And of course, following that up, I heard this crazy story that the machine at the coin factory suddenly stopped working. It just doesn't make sense. Anyway, so what I'm first going to respond to is I heard a reference to on the MMTLP I'm discussing. I heard yesterday there was some discussion about perhaps there being an offer for at a certain number for shares that were made to certain shareholders, and I don't know if that occurred or didn't occur. No one is. I'm suing or am in arbitration with Fidelity, and certainly, as to my matter, nobody's made me an offer. And if they do, I will certainly advise the community and everybody if that happens to the extent I can, at least an offer. But I'm not aware whether offers have gone out or not, but I have a take on that a little bit. But there was some discussion yesterday that there may have been offers that went out at a particular price to some shareholders. And I was thinking about that and how that could easily be misinterpreted or misconstrued or miss something, maybe Mississippi. And I'll give you an example. So let's say Fidelity, and it was Fidelity. Fidelity was supposedly the company that was reaching out to some of the shareholders of MMTLP and making an offer of some number. So let's say Fidelity approached me, and we're just talking for discussion purposes, and they said, "We'll offer you $5 billion per share if you agree to sell us your shares of NextBridge." And they ask me, is that a yes or a no? And that's an offer as to a contract. And if I say yes, then we have an agreement. It may be subject to writing. So it may still require a writing because there may be additional terms and may be a need to agree to those additional terms. But there is, in essence, an agreement. And again, it may fall out because there might be an issue about confidentiality provisions or other provisions or liquidated damages provisions, other issues. But for all intents and purposes, there's an agreement. And under those circumstances, if someone said that Fidelity had made an offer of $50 billion per share, they would be correct. But there's another way that, and again, could be subject to a writing, which also might be a way out. But let's assume that the writing is not an issue. But another way that same fact pattern could be presented is what happens if Fidelity called me up and said, if we offered you $50 billion, would you sell us all your shares? And someone might interpret that the same way as the first example. However, that's not a contract. That's not an offer. That's more what I would say is a probe. And it could be easily misunderstood. So, whereas the first example, where there was actually an offer and an agreement, the Fidelity in that case would be obligated to make that payment. In this second case, it may have been a tactic to ascertain or probe what the shareholder might want to do. So, for example, let's say that call happens, somebody says, here's $50 billion, and I say, absolutely yes, quickly. Well, they know that they could offer less and still get my assent. And the converse is true too. Let's say they offer me $50 billion and I say, heck no, I want nothing less than $500 billion. Then they would know that I would need more, but it would not harm them. They would be able to gauge basically the breadth of the settlement numbers by kind of just probing. So someone might receive that information and in the moment not recognize which one it is. And they may believe that one happened and it might have been the other happening. So I don't know if there was an offer. I don't know if there was an offer subject to a writing, or I don't know if there was a probe. But those are all things that I considered. And I know for myself, I've not received anything. And just as a follow up today, I filed my fourth special motion for discovery in my arbitration. And again, I'm in an arbitration against Fidelity, against MMTLP. And to refresh everybody's memory, in an arbitration, a FINRA arbitration, your rights as the claimant, me, on behalf of the community and with the community, for discovery are limited. And to get more broad and more normal discovery, you have to show extraordinary circumstances. So here we've argued because of the U3 halt, that's the extraordinary circumstances as defined by FINRA. So I've made 3 requests for various depositions of various people, including the head of Fidelity, Gary Gensler, and 8 other individuals. And I've requested various documents throughout. And today, in response to what I'd heard about this potential communication between Fidelity or their agents and MMTLP shareholders, I filed a new motion on the same grounds of the extraordinary circumstances as found by FINRA per their U3 halt, asking for documents that might be relevant to this area involving this particular category. So I also said I'd like to depose any witnesses that might be involved in this particular area. And this just involves the issue of the communications between Fidelity or their agents and any shareholder of MMTLP or NextBridge from December 9th, 2022 to the current time, where the issue of the sale or potential sale, or whether it was a probe into that of MMTLP or NextBridge shares was discussed. So any document that reflects that or refers to that, and there's multiple categories, and then any witnesses who would know that. And that way, and I'm sure there will be an argument because there's a particular legal issue that will come up, I expect. And I'm telling you that now. I won't address it because I don't want to clue in the other side. But when they raise it, I'll remind you what I'm talking about. But I'm sure that this will be litigated in terms of what I'm asking for. But I believe it's perfectly reasonable under the circumstances, and we shall see. So that's my take. I'm not going to say whether it happened or not because I don't know, but I gave you 3 or 4 different alternatives, and now I'm trying to ascertain what communications may have occurred, and we'll see if I can obtain them in my arbitration. And of course, I'll keep everybody updated as to that. The second point I wanted to briefly address was I saw a reference on X last night about fines that Goldman Sachs had paid for various documentation and coding errors they had made. And the person's premise, I believe, was that since 2001 to the current time, in light of the most recent fines that were imposed, that Goldman Sachs will have paid $13 million. And the person said that was a substantial amount and that would really impact them, et cetera. I think that was their basic premise. And they also indicated that It's basically a two-part fine because they were fined for conduct from 2001 through 2013, and then they paid a fine and I guess were punished, and then they were fined from that period of time through 2022 for a second round. Again, the same inaccurate documentation, record keeping, etc., and whatever other shenanigans were going on. So the person who was making the point indicated that that was a lot of money to be fined, and whatever, that it was quite a punitive move. And I was thinking that ends up being $600,000 per year approximately, which I don't think Goldman Sachs even notices. I think they probably pay their sanitation crew more than 600,000 a year. So that really annoyed me, by the way. 600,000 a year for nothing. But beyond that, what concerned me even more is since they were penalized in 2013 for all the conduct that happened up prior to from that till 2001, that whole block of time, 12 years, they were penalized. And then it happened again, 2014 through 2022. So at some point in time, with a firm of the stature of Goldman Sachs, you can't believe that they're so incompetent they would hire incompetent people. You would think at some point in time that maybe if they continue to do certain conduct, that somebody might construe that as intentional. So perhaps they were, and I don't know if this is true, but perhaps they were intentionally mismarking them. I certainly know I would make that argument in light of the ruling in 2013, because it makes no sense why it would happen again for another 8-year period, and they're paying nothing. $600,000 is nothing. Does nothing to these guys per year. So that's that. That's a quickie on Goldman. Last but not least, and we'll have to see where this goes, but per Reuters, the SEC has collected a bunch of, we'll call them burner phones, from various firms, including Citadel. And so I have a friend who works in the securities business, works for a brokerage, and they are very specific. They hand them out a phone that can only be used for business. And they do that because people are, when they use a business phone like that and they understand that's the only phone for business, they're cognizant of that. They're careful about what they say, and they understand that it could be subpoenaed or text messages could be obtained or anything like that. So there might be millions, literally, of these text messages. And apparently, companies like Citadel, and I'm going to focus on Citadel because they're probably the biggest, but there's a bunch of big hedge fund capital firms. I focus on Citadel because of their nature of shorting. But apparently, many of their associates' phones have been taken in by the SEC, and the text messages, which these people thought were private. So these are on their personal phones, but they use their personal phones for business purposes. So now they've made them available to the SEC and potentially to the Department of Justice. So the SEC has apparently acquired them. There's rumors, and who knows that they're true, that there's very compromising information on many of these phones because, again, these people might have thought these conversations were private. And since Citadel was a huge shorter of shares, last year they made a ton of money. I think from hedge fund position, they may have been the most profitable hedge fund, and they were certainly one of the biggest shorters. But apparently they're one of the targets of this. So apparently the SEC is the one who's made the request and has all this information. But I wouldn't be surprised if the DOJ also gets access to the information. And if, as I suspect, it has compromising information, there may be associates at these various firms that might turn state's evidence to protect their own skins. Just speculating. But it'd be very interesting to see what comes out of these text messages from these various firms and what happens with regard to the SEC and the DOJ. Of course, I will keep you apprised. Anyway, have a great night and be well. Take care of yourselves. Talk to you later.